And secondly, my lord, the second development is that regarding the second docket, First Flores CAS 375 of 1 of 2019, which pertains to a charge of defeating the ends of justice. The National Director of Public Prosecutions has since transferred jurisdiction in respect of this docket from the area of jurisdiction of the Director of Public Prosecutions, Johannesburg, to the area of jurisdiction of the Director of Public Prosecutions, Pretoria, and has accordingly amended the first direction, which deals with the...
A bit slow.
Sorry, my lord.
We do not have that directive or that communication. It has not been shared with the parties before it's placed on the record, my lord. As the court pleases.
Please, I'm sorry, my lord, it was meant to be given to my colleagues this morning. But I'm doing so now, my lord. And as I've just intimated, my lord, the main docket that gave rise to the current charges that are serving before this court, the directive in respect of that docket says as Exhibit AA before court. So,
by the way, the docket that has been transferred is CAS number
375 of 1 of 2019.
Yes. Yes. Yes.
So that, my lord, the Director of Public Prosecutions, Pretoria, is now seized with both dockets. First Flores CAS 636 of 10 of 2014, to which the current proceedings relate, as well as now First Flores CAS 375 of 1 of 2019.
Meaning that with regard to that docket, there is a possibility, or I don't know, I shouldn't use words that I invent myself, but let me borrow this word. There's a possibility that that docket will serve in one way or another in Pretoria, and there may, and I repeat, may be proceedings based on that docket here in Pretoria before another court, meaning before another presiding officer.
A decision, the original docket will be requested, studied, and the Director of Public Prosecutions will take it from there.
All right, okay.
My lord, I'm not going to burden the record by handing up this directive, as the current proceedings don't really relate to First Flores CAS 375 of 1 2019. I've just handed the direction to my learned colleagues. This is just merely to apprise the court of the developments in this regard.
Yeah, well, my sense is that there's a bit of irrelevance with that.
Yes.
Concerning what we are here about.
Yes, indeed.
All right, okay.
Then, my lord, the third significant development is that there was an application for stopping of the proceedings in terms of Section 6B of the Criminal Procedure Act 51 of 1977 on behalf of accused number 1 to 4. And that application, my lord, has been declined. And Mr. Tobani, who appears for accused number 1 to 4, has been informed accordingly.
Just a bit. Yes.
My lord, this matter is partly heard before you. And Advocate Nshololo for accused number 5, still busy with the cross-examination of Sergeant Musia, the first state witness. And Sergeant Musia is present in court.
Yes.
And Advocate Nshololo has signaled her intention to bring an application in terms of Section 317 of the Criminal Procedure Act. For a special entry to be made on the record of an alleged irregularity, since the matter must still be ventilated before this court, for having received copy of the second docket, Fossil Arrest 375 of 1 of 2019, during the cross-examination of Sergeant Musia. And not before the commencement of the trial. And that, my lord, that had they received it before plea, they might have perhaps pleaded differently.
Objection, Your Worship. Your Worship, that's the application by the defense. There is no need for the state to bring either whether the introduction or whatsoever before this court. The state is the respondent in this application, and therefore it's got nothing to do with introducing the proposed application.
So I was just merely informing the court of the order of business for today. And I'm not taking it any further than that. And my lord, in light of the arrangements that we have made in chambers, regarding the further conduct of the proceedings for today, Namely, my lord, that is now as far as the cross-examination is concerned, that we have furnished the defense with the originals of certain exhibits that are serving before this court, namely the exhibit register, the SAP 459, as well as the original docket of Sergeant Musia that he has repeatedly referred to in his evidence. These original documents were received on Friday, hence they were only given to the defense this morning. They would like to go through those documents, my lord, and we, in terms of the arrangement, the cross-examination of Sergeant Musia will resume tomorrow morning to give the defense the opportunity to peruse those original documents. And my lord, it's for that reason that we request that Sergeant Musia be excused for the rest of the day, my lord, as still having health issues. He can be warned for the court for tomorrow at 10. It's the court, please.
Morning, Your Lordship. I confirm my appearance on behalf of accused 1 to 4.
Yes.
I confirm my appearance on behalf of accused 1 to 4.
Yes.
I also confirm that we did receive transcripts, soft copies, Your Lordship. With regard to the hard copies, my colleagues advised us that they are still in transit. They send them by courier service. We have not yet received them. I do confirm that we have seen the letter from the state with regard to 375. However, I'm concerned, Your Lordship, because the Lordship put it very clear that 375 is irrelevant in these proceedings as we deal with 636. However, the pending application from accused number 5, it will deal with 375. And furthermore, on the 26th of August, 2022, we received a letter with regard to 375. This letter is different from the one we are receiving today, Your Lordship. And therefore, it's an explanation from the state side why this letter is different from the one they sent us by email, which is causing confusion to the proceedings in 636. Because according to the letter we received on the 26th of August 2022, the letter is very clear. It says, decision will be made on 375 after the conclusion of 636. Which creates a mockery to the whole proceedings, Your Lordship, with due respect.
Are you saying it is relevant here for now? Here, because you will remember for some time now I've been reiterating that for me, because I'm not Dominus Litis, I sit here and the state brings cases based on dockets. And once it lands here, I deal with what is before me. Now, you started well saying that you are concerned that Advocate Mshololo may delve into what is not before me. But you now also seem to be doing the same.
Your Lordship, I'm very concerned, and I agree with the court that 375, the court has made the decision that it is irrelevant with regard to the proceedings of 636. However, if the court entertains the application that is pending of 375, based on 375 docket, it will make it relevant. And even this letter on the 26th of August 2022 then makes it relevant to the proceedings. It's like Siamese twins, they are joined by heads with different body parts.
I don't fully understand you. I don't know. You say by virtue of it being mentioned by, maybe for argument's sake, by Advocate Mshololo, it will make it relevant.
To add on that, even the Honorable Court postponed this matter for the fact that attorneys, representative of accused number 5 must go through 375. That was the reason for postponement,
Yeah.
which we accepted.
Yeah. Remember, matters of relevance and irrelevance, the way they pan out is that you rise here, or Advocate Baloyi rises, or whoever, Advocate Mshololo rises, and you present the bench with whatever you present the bench with, and then the issues of relevance or otherwise then come into play, and a decision may have to be made. Sometimes an objection may be made, sometimes there may be submissions from all sides, and the bench may have to make a ruling on the question of relevance. I don't think it may be for you to sit there and to stand there and say what my colleague is about to present is irrelevant, and then I don't think I may be able to then make a ruling based on what you have said without listening to her.
My Lordship, I do agree with the court 100%. I don't want to say that what my colleague is going to be irrelevant, is going to present is irrelevant, and I don't want to jump the gun. I'll give them the opportunity to do that application. The point I was trying to stress here, Your Lordship, is that the state is like playing chess games. They inform the court about this letter but doesn't hand it in. Whereas this letter that was given to us today is different from the one we received by email. And my last submission will be that I'll let representative of accused 5 to continue with the application. Then when we will reply, we'll deal with these all issues from the state side and including that application, Your Lordship.
Yeah, I think I agree with that approach.
Thank you.
We are at tea time. We will adjourn for tea. Maybe before we adjourn, there's a matter which is for postponement. When we return from tea, we will start with postponing that matter quickly. It will be just a mere postponement, and then we'll continue with what we are busy with.
If it suits the court, can we then ask that Sergeant Musia be excused for the rest of the day?
Sergeant Musia, you are excused. You will return here tomorrow. Make sure that by 9:30 you are here, so that we start in time. I don't need to remind you. You know that how to behave when you have not yet been excused from giving evidence.
Ka lokoleha he monghadi Musia hobane tsatsing lena ha re tlo tswela pele ka case ena ka baka la bophelo ba hao bo seng botle re re tsa mo phomola o tlo fumane matla ka osane o tle o le matla hore re tlo tswela pele ka case ena netefatsa hore bonyane 9:30 o so fihlile bakeng sa hore ha re qala o bo sontso o le teng wa tseba he melao ya ha o santsane o le ka tlase ho kane hore wa tlameha ho bua le motho ka tsohle tse ntse di etsahala ka lekgotleng ebile he le wena jwalo ka paki la o sa ihlahise pela lekgohle o tlo o kana ntshetswa lengolo la tshwaro ebe wa tshwara e a tsebahala ke re monghadi kapa e utlwahetse
Who tlies Morena?
understood my lord
All right.
provisionally be remanded to Thursday this week, just in case anything happens to this present matter that the court is going to pursue today. I don't know if that will be feasible.
Advocate Baloyi, you think that is advisable?
Well, I don't think so, my lord. I think we are due to continue for until the 15th. I think we are set down until the 15th.
Well,
So
I don't know what the reason is, but he seems to be hoping even against hope itself. Maybe let's, does it cause any inconvenience if we postpone it to Thursday just to see whether what he's hoping for will materialize?
it shouldn't be a problem, my lord.
There won't be any witnesses being warned?
No, my lord, I actually excused them because I realized that it's going to take time, so I will subpoena them again. They were here, they will be subpoenaed again.
So they won't be here by Thursday?
No, Thursday I can bring them if the matter continues. I'll make sure that they are here just in case we proceed. If we proceed, they will be available.
May it please the court, my lord. M.A. Madira for the accused. Madira. My lord, as alluded by my colleague, we have agreed to remand this matter to the 30th of January, as my colleague has alluded to the court. However, my lord, I just have a...
30th of January?
Yes, 2023 to the 11th. I just want to address the court in regards to the date of the 8th as proposed by my colleague.
Yes.
Because it appears to me as if we're not sure, we'll just be hoping that the matter won't proceed. And in light of that fact, my lord, it is my opinion that postponing the matter to a date where we are not certain whether the matter will proceed or not, will just be fishing around, my lord. We rather postpone the matter to January, where we are sure that that date is reserved for us. Because in any case, if we come here on Thursday and the matter is not proceeding, it's costly for my client. And that is, every day I'm here, obviously I need to be paid. And if I'm here and we are not proceeding, that is prejudicial to the accused, my lord. And also to clarify the position with regards to the accused. The accused is on bail in respect of this matter. However, he's in custody on another matter that's appearing in Pretoria North Regional Court. I believe the record would reflect that on the previous occasion he was granted bail in this particular matter. And with all due respect, my lord, I submit that this matter be postponed to the 30th of January so that we are certain that those reserved dates will exclusively be for us to proceed further with this matter.
Advocate Kalipe?
Yes, court, please.
My lord, I cannot argue with Mr. I was just hoping, in fact, I spoke to my office and they suggested that in case this matter comes to a halt, then we could utilize those days that are remaining. Well, we were sure that we are going to proceed today, and here we are. We can't proceed. So that is basically against that background that we suggested Thursday.
Mr. Kalipe, you are a man full of hope. You're still hoping to proceed?
No, I'm not hoping. I'm hoping, my lord, but I can just hope that it will happen. Otherwise, things happen, circumstances changes every time.
In chambers, there's this case that is running, and we did agree that we are going to prioritize it for so many reasons.
Scott, please, I will then settle for the 30th of January.
You said the 30th of January.
Yes.
Yeah, that's the other thing I wanted to raise, because earlier on you spoke of the 10th of February.
Oh, sorry, no, it's 30 January to 10th February.
My lord, furthermore, we request that the bail of the accused be extended to that date.
Do you agree, Advocate?
As a court, please, my lord, I agree that earlier on I said he's in custody, but in respect of this matter, he's indeed on bail.
This case is postponed with the accused in custody, postponed to the 30th of January 2023. It is postponed so as for it to proceed from the 30th of January 2023 up until the 10th of February 2023.
As a court, please, my lord.
My lord, before we stand out, I guess my lord made a mistake saying the accused in custody.
Oh, the accused on extended bail. I'm
As the
sorry.
court pleases. And that was a short roll before you and later to you may be excused.
May I also be excused, my lord?
Well excused.
Lord, before I start with the proposed application, may I just respond to the submissions made by the state earlier on?
Yes.
My Lord, the state has made submissions regarding the direction which has been taken by the National Director of Public Prosecutions. And such directive is contained in a document dated the 22nd day of August 2022. My Lord will note that this letter has not been communicated to myself as the defense counsel for accused number 5 for the reason only known by the state, which is also irregular and unlawful.
Yes.
The state, my Lord, further submitted that it is not intending to hand in this document to the court because from their side, they think it is irrelevant when it contains the violation of the accused's constitutional rights before this court. Therefore, I submit and request, my Lord, that this directive from the NPA be marked as be submitted to this court and be marked as an exhibit because it is crucial to the defense case and it will be used during the arguments on merits of this case. I therefore ask that the original letter be handed into the court so that it can be marked properly, my Lord. That's my first submission, my Lord.
Should it of necessity be the duty of the state to do that? Can the defense not come up with that document on its own?
We did not have,
Instead of compelling an unwilling party to do that, since you have a copy thereof.
my Lord, the problem is that we have not been given this document. It has been given to us here when the state was already making the submissions. That's the reason why we did not have access to this document before we started.
Advocate Baloyi?
As a court, please, my Lord, we have absolutely no objection to the directive being handed in. In fact, the DPP mentioned in the letter that the directive will be handed up as an exhibit. But, you know, on closer reflection, I just thought that it will not be necessary. But we did mention it in the correspondence. We can mark it exhibit AAA since the the other directive, I think, is AAA. So this will be exhibit AAA. I'll hand up the original this afternoon as a copy.
Mr. Tobani?
Your Lordship, don't have objection. The only reservation is that, as I did inform the court, there is another letter before this one. Preferably, this other letter should have been marked the first exhibit before this one. May the court humbly request the state to deal with that as well, so that they can go together.
As the court pleases, my Lord, there's absolutely no objection. A copy of this letter dated the 26th of August 2022, will then be marked just to keep the exhibits together, my lord. We can make it AA.
Do you agree? Advocate Msholo, do you agree?
Yes, the court will this, my lord.
Yes.
Thank you, my lord. My lord, lastly, on these exhibits that are now before court, the state submitted that the docket in respect of case number 375, of 2019 has no relevance. But my lord will see in paragraph 3 of exhibit AA,
Yes.
which reads as follows, my lord. Paragraph 3. In light of the fact that the decision for Lora's case 3751-2019 depends on the credibility findings by the trial court in the current trial involving Force Lora's case 636-10-2014, I have therefore decided that the decision in Force Lora's case 3751-2019 will be made at the conclusion of the current trial. Therefore, my lord, I submit that the docket, police docket as per Force Lora's case number 375/1 of 2019 forms part of this trial. It is not true, it is not correct to say it does not.
Are you saying that? Are you saying that we will call the witnesses in that case as state witnesses
In that trial,
in this trial?
in this trial, yes, they will be called as the state witnesses. Those who have, I will elaborate that, my lord, in my application for the special entry. I just wanted to make it to the court to say, it is not true to say that it has got no bearing in the trial that we are dealing with right now. My submission is that it have. It does, my lord.
Yes.
And the two exhibits will be used during the trial. May I then move on to the intended application, my lord?
Yes.
Sorry, just before my learned friend continues, and just to clear up any misconceptions, what I meant at this stage was that the current trial is about 636 of 10 of 2014. Of course, 3751 of 2019 can be used in cross-examination. I refer to the fact that this current case is about 636 of 10 of 2014. As I say, 3751 of 2019 can of course be used in cross-examination. Thank you.
Yes.
Thank you, my lord. My lord, I would like to bring the application in terms of section 317, subsection 1 of the Criminal Procedure Act 51 of 1977, which is an application for a special entry to be made on the record regarding the proceedings which are irregular or not according to the law in the following terms. My lord, I have included in the notice of the application the grounds or the terms. I don't know whether I should repeat them or can I just continue with the submissions, my lord? Or maybe for the sake of record, if I can just read it.
Yes.
Okay, thank you, my lord. Number one, the respondent or the state failed to furnish the applicant with further particulars, including the content of the evidence contained in the police docket for Sloras case 37501.
When will I get a copy of what you are reading?
My lord, I thought it was handed in chambers by Mr. Sibia. Or maybe, my lord, may I just beg leave to hand in another copy?
Okay. Yes.
Thank you, my lord. That's the copy that I intended to submit before his lordship on Friday, my lord. I'm on paragraph 1, my lord.
Yes.
Thank you, my lord.
And I think you.
I've read it.
You are well aware that this never reached.
Yes, my lord.
Never reached.
Yes. That's why I'm asking, my lord, for the leave to read it into the record so
Alright,
that it will be
okay.
easier. Paragraph 2, my lord, if I can proceed. The respondent state had been aware of the existence of the police docket for Sloras case 37501. Sorry, my lord, 2019 is not 1022, that's a mistake, my lord. It's supposed to be 371/01 of 2019. (375/01/2019), and its contents or evidence at the time when the decision to prosecute the applicant was made. Number 3, my lord, the respondent or the state failed or deliberately ignored without a just cause to consider the relevancy of the contents of the evidence in Foslora's case 375/1 of 2019 in the prosecution of the applicant under the Foslora's case 636/10 of 2014. Paragraph 4, the applicant therefore would not have pleaded in the manner he has pleaded had he been furnished with the further particulars, contents / evidence contained in the Foslora's case 37501. Number 5, the contents or evidence contained in the police docket Foslora's case 375 was obtained immediately after the incident occurred from the same crime scene of the Foslora's case 636/10 of 2014, which the applicant pleaded into. Number 6, the content of evidence in docket Foslora's case 37501 2019 ought to have been disclosed to the applicant before he pleaded. The applicant's constitutional right in terms of section 35(3) of the Constitution has been violated in that the applicant was not provided with sufficient detail of the charge before he pleaded. Number 8, as a result, the conduct of the respondent, the state, has rendered these proceedings not in accordance with the law. The furtherance of these proceedings is both unconstitutional and not in accordance with the law. The application is bona fide, not frivolous, and it is not the abuse of the court process. Those are the bases, my lord, for the application. My lord, in my arguments, I've also submitted the heads of argument. May I also double check if the court has received the copies of the heads of arguments from both the applicant and respondent?
Yeah.
My lord, they were left in his lordship's chambers when we were in the chambers before we came here. Mr. Sbiya brought them, my lord.
Were they handed over or were they just left behind where you were seated?
Aish, my lord.
I mean,
May
if
I
it's,
assist, Your Lordship? I
we
think-
know we were in chambers. I saw you holding papers. I didn't hear anybody saying, here are papers, or my secretary saying, here are papers.
My apologies, my lord. I thought they have been properly handed to his lordship. My apologies, my lord. My lord, may I also beg leave to hand in the applicant's heads of arguments as I'll be continuing
Yes.
with my arguments.
Yes,
Thank you, my lord.
yes.
My lord, it is a common cause and it is evidence before this court that the applicant pleaded before this court on the 22nd of April 2022. And my lord, it is also common cause that the second docket was disclosed or furnished to the defense counsel in the middle of the trial. And to be specific, my lord, during the cross-examination of the first witness. My lord, it is for that reason that this application is brought before this court in order for this court to record an irregularity that has occurred. My lord, the provisions of section 317 specifically provides as follows. I'll just read 2 lines of the section, my lord. It says, if an accused is of the view, my lord, that any of the proceedings in connection with or during his or her trial before a high court are irregular or not according to the law, she may either during his trial or her trial or within 14 days. I'll pause there, my lord. Can I proceed, my lord?
I'm just marking them.
Oh, my
They came
apologies.
unmarked.
Sorry. Thank you, my lord. My lord, I have included the full section in my heads.
Yes.
And as a result of that, my lord, the applicant is bringing this application at this point in time before this court because of the protection offered in terms of Section 317. To bring it to the attention of the court, an irregularity which is not clear on record. My lord, I submit what is not clear or what is not appearing before this, what is not clear in the proceedings is that, number one, there was an existence of the second docket, which is case, Foslorus case 375. And I would ask my lord that I refer to it as the second docket, meaning the Foslorus case 375, my lord.
Yes.
Without the applicant bringing this to the attention of this court, the court will not have known that there was a second docket that was opened by the state, and the witnesses, statements from the witnesses, my lord, on the same facts and same cause of action and on the same offense the applicant number 5 is facing before this court was opened. My lord, I submit that docket or that information contained in that docket ought to have been disclosed to the applicant so that he would have been able to prepare his defense.
Yes.
My lord, without prejudicing the trial, the main trial, but I would like to briefly elaborate to the court as to the nature of the evidence contained in the second docket. The second docket, my lord, contains the photo albums that were taken in the crime scene, when the incident took place, on the following day when the incident took place in this matter. That information is crucial to this trial. Secondly, my lord, the second docket contains the statement, which I may call it the second statement, of Sergeant Mosia, who is testifying before this court. And in that statement, he is contradicting himself. Had the applicant been given access to that statement of Mr. Mosia, he would have been able to prepare his defense case properly, my lord. The second docket, my lord, thirdly, I'm not sure when I'm too fast, my lord.
Yeah, let's proceed.
The second docket, again, my lord, contains the statement of Brigadier Ndlovu, who has been referred during this trial by Sergeant Mosia as the person who was giving him authorities and indications, if I may put it, my lord, to say, who played a role in the investigation of this matter. And that statement has not been disclosed. To the defense. When it contains material evidence, my lord, if I may put it like that, regarding the evidence of Sergeant Mosia, who is on the witness box. It contains material evidence regarding the involvement, if I may be specific, my lord, of Sergeant Mosia, who has testified or who is still testifying before this court. And therefore, that information, my lord, ought to have been supplied to the defense.
Yeah.
Thirdly, my lord, this is also contained in my heads of argument. It contains the statement of Warrant Officer Mishek Kumalo regarding the status of the witnesses who have submitted the statements under Phosphorus Case 636. Makubo, my lord, sorry, not Kumalo, Makubo. Warrant Officer Mishek Makubo. And therefore, it cannot be said.
You say that statement has to do with?
The statement of Warrant Officer Makubo regarding the status of the witnesses who have submitted statements under Phosphorus Case 636/04 of 2014, which is the first document, my lord.
(636) of
04.
Yes.
There's no 636. 636/10/2014, my lord.
Yes.
And without testifying, my lord, I'll just briefly making reference, regarding the relevance of the disclosure of the statement of Sergeant Makubo to the first applicant before he testified, is that he is referring to the information or to the evidence.
Yes.
That was obtained at the time or during the time of the commission of this offense that we are busy with, my lord.
I don't understand you. You say evidence obtained during the commission.
During the commission of the offense in case number 636. My lord, in this case,
Was it during the commission or during the investigation?
during the investigation, thank you, my lord, during the investigation.
You are giving me the impression that as the offense was being committed, somebody was obtaining evidence at the same time.
No, my lord, it's just the way of putting it, because it
Okay.
involves
No,
the.
I'm clear now.
Thank you, worship, my lord.
Yes.
And though the witnesses referred to by Warrant Officer Mishek Makubo are contradictory to the evidence contained in the first docket, which is case 636 of 10 of 2014. My Lord, I will end there.
Just for my
Sorry, my Lord.
better clarity, are you able to give me clarity about where you are concerned? Which of the two dockets was first to come into existence?
Sorry, my Lord.
Which of the two dockets was first to come into existence?
It's 636, my Lord, because it was opened in 2014. (636) was opened in 2014, my Lord. And 375/01/2019 was opened in 2019. (636) was opened in 2014, and 375 was opened in 2019.
Yes.
For the reason why the second docket was obtained, my Lord, it is a matter of trial. But the point I'm making before this honorable court is that the information contained in the second docket ought to have been disclosed to the applicant before he pleaded. And the state, my Lord, was well aware of the existence of this docket. And to answer the question, my Lord, to say, therefore, where does the infringement comes from? The infringement, my Lord, comes from the violation of Section 87 of the Criminal Procedure Act, which gives the applicant a right to request further particulars from the state, which offers also the applicant with a right.
You say Section 87?
87, my Lord, of the Criminal Procedure Act. Therefore,
Yes.
the applicant has been enabled to use the provisions or the protection offered in terms of Section 87 of the Criminal Procedure Act, because he was not aware of the existence of this information, and the state was aware.
Are you saying enabled
Enabled, yes, my Lord, and enabled
to?
to use, to enforce the right that is offered in terms of Section 87, my Lord. That
Are you saying he was made to be able to use? Is that what you're saying?
he was made unable.
He was disenabled.
He was disenabled, yes, my Lord,
Okay.
to use these provisions, because he was not aware of the existence of the information that is contained in the second docket. And when the discovery was made, my Lord, the applicant would have approached this court for an order compelling the state to disclose this information or to furnish this information to the applicant. And the applicant did not do that because he was not aware and had not been furnished with that information. That is how the violation, my lord, I submit occurred, which amounts to an irregularity or not according to the law. My lord, the state has responded to say it is premature for the applicant to bring this application for a special entry for the court to note this irregularity on the part of the applicant. My lord, I submit that
As a court, please, I don't think it's proper for my learned friend to preempt what the state is going to say. She can make her argument and then reply, to the state. But I don't think it's proper for her now to already foreshadow what the state is going to say. She has the right of reply.
Advocate Msololo?
my lord, I have been submitted, I've received the heads of arguments from the state. Maybe I should read that paragraph to the court before I can make submission.
Well,
It's contained in the
Well-
heads of arguments.
well, shouldn't you wait? What if he changes his mind on it?
As the court pleases, worship.
Shouldn't you wait for him to present? Then, as we know,
As the
you
court
will
pleases.
have an opportunity to.
As the court pleases, my lord, I thought they were sincere. Thought they were genuine with that submission, my lord. I will rephrase, my lord.
My lord, it's not a question of being genuine or sincere. It's a question of procedure. She'll have the right of reply,
Yeah.
at which point she can then raise this issue. It's about procedure.
If you ask me, this bickering is not important. It's not necessary. I think she has admitted that she will wait for you to respond, and she will get an opportunity after Mr. Tovani will have also responded.
But then she makes this cutting remark about sincerity. It's got nothing to do with sincerity. It's about the procedure.
Advocate Msololo?
My lord, with due respect, I ask not to respond to that submission, my lord. Can I just,
No, what am I to make of it? You have made it, it's on record.
My lord-
It's like two people fighting to board a taxi.
my lord, as
It will
I,
pass as you
I
are.
have indicated, my lord, to say, I read it from the state heads of arguments.
But
Hence,
are
I
you
brought
not,
it
are you
forward.
not ahead of yourself by responding before we listen to him, as we should do in every case?
I have already acknowledged that, my lord, to say, I thought the submission contained here. It's genuine, that's why I put it up forward. But after I've been advised by the court, I'm just withdrawing it, my lord.
The wrong thing that you did is to suggest that he was being disingenuous in submitting, in doing that, because that's how it's done. You address.
My apologies, my lord, if it caused confusion.
Yes,
It was not intended to.
okay. Let's proceed.
My lord, I was making the submissions to say, therefore, the only time that the applicant ought to have brought this irregularity before this court, it's at this point in time, and not during the appeal, or not on appeal. The provisions of Section 317 are very clear, my lord, to say for the trial court is just to make an entry on the irregularity, the issue of whether An entry or entries on irregularities ought to have been made by trial court is the issue of the appeal court. But a special entry has to be made during trial. In order for it to be recorded, my lord. Secondly, my lord, regarding the violation of the applicant's constitutional rights is in terms of section 32 of the Constitution, my lord, which has been violated by the state, which says everyone has the right of access to any information held by the state. I'll put emphasis, my lord, on the last part of this provision of the Constitution to say any information held by the state. The state in this matter, my lord, has been in possession of the second docket at the time when the decision was made to prosecute in this case. The information contained in the second docket the state was aware of when the charges were put to this court and when the accused pleaded. Above the violation in terms of section 32 of the Constitution, again, my lord, the violation in terms of section 35, sorry, my lord, the right, constitutional right of the applicant protected under section 35, subsection 3, which says, every accused person has a right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. To have adequate time and facilities to prepare a defense. And the applicant in this case, my lord, he has not been afforded with sufficient information, which was available to the state in order for him to be able to prepare his defense. And therefore, a violation has been created by such conduct of the state, my lord. Without debating and wasting the court's time whether the second docket is relevant or is not relevant, I submit, my lord, it is relevant because it contains information from the same facts of the case that we are currently dealing with. And for the reason why these two dockets were not considered by the state when a decision to prosecute the applicant before this court also amounts to a violation of the accused's constitutional rights. He has been prejudiced by such failure on the part of the state to consider the evidence contained in the second docket, wherein there are people who are implicated there, and the state has decided not to charge them and only charge accused number 5.
Yes.
Sorry, my lord, I just misplaced my paper. Thank you. My Lord, I've also referred to decided cases which are contained in my heads of argument.
Can I just check in terms of your heads and everything in submitting, are they in Word format? When you submitted everything to the secretary, has this been submitted in Word format?
Yes. My apologies, my Lord. It was submitted in PDF. We can change them to a Word
Yeah,
format.
please do,
Thank you, ma'am. We'll change them, my Lord.
please do. Yes?
The case of S versus Nkabinde and others, 2017, volume 2 SACR 431, in brackets SCA, at paragraph 27. The court held that, as is shown below, all the so-called special entries are not proper special entries but grounds of appeal under section 316 of the Act because they appear on the record. Some 60 years ago, this court, the SCA, my Lord, held that the special entry procedure is of vital importance and should be utilized where the irregularity does not appear on the record of the proceedings.
Yes.
My Lord, it is because of this authority that the applicant is making this submission before this court, for the court to note an irregularity that does not appear on the proceedings. The irregularity on the non-disclosure of the second docket, which contained information which was relevant to the applicant in preparation for his case.
Yes.
And furthermore, my Lord, to satisfy the requirement in the provisions of section 317, which says the application for a special entry is to be made bona fide or that it is frivolous okay, my Lord, may I just read the whole section. The judge to whom the application for a special entry is made, if that judge is of the opinion that the application is not made bona fide, or that it is frivolous or absurd, or that the granting of the application will be an abuse of the process of the court, the court shall refuse to make a special entry.
Yes.
My Lord, it is my submission that this application is made in good faith, bringing to the attention of the court the non-compliance of the provisions of the Criminal Procedure Act, which is section 87, the violation of the constitutional rights of the applicant, and the application that is brought before this court cannot be said to be an abuse of the process.
Yes.
Because the applicant, my Lord, submits that he would not have pleaded the manner in which he pleaded. And therefore, he has been denied a right to a fair trial. Without prejudicing the applicant's case, my lord, the applicant would have pleaded the other way, including bringing the application objecting to the putting of the charges. There are so many ways, there are so many pleas the applicant would have opted or would have looked at had he been aware of the information contained in the second docket.
Yes.
My lord, the purpose, lastly, the purpose of bringing a special entry to be recorded in this record, it's for the appeal court to see that such an irregularity was brought forward to the attention of the trial court and it was recorded as a special entry. My submission, my lord, is that what I have submitted before this court amounts to an irregularity, and it is not according to the law, and such irregularity has to be recorded. As the trial proceeds, the applicant is prevented, my lord, if I may put it like that. The dent that has happened cannot be rectified. It's non-repairable, or it's irreparable, because evidence has already been laid, and there is no way it can be rectified. The plea, my lord, cannot be amended at this stage. The decision that was made by the applicant to remain silent cannot be amended at this stage. It is there, it is recorded, my lord, and it will be used against him. Even not against him, but it will be used when the merits of this case are considered. At this point in time, my lord, when the trial proceeds, accused number 5, which is the applicant, he is prohibited. He has no way. He doesn't know anymore how to conduct his trial further. And my lord, I submit.
Just for my clarity again, can a plea not be changed at this stage of the...
My lord, I submit it cannot at this
Why?
stage.
Why?
Because there is evidence which has already been laid.
Yes.
Those are our submissions, my lord, in respect of the special entry, my lord. Thank you, my lord. Those are our submissions.
Advocate Baloy,
As a court
is
pleases,
it
my
you,
lord.
is it you should come now, or is it Mr.?
No, I think Mr. Tobani indicated that will come at a later stage, my lord.
Okay.
Yes. My lord, the state respectfully opposes the application. We have filed a notice of opposition wherein we stated that the affidavit of the investigating officer will be used, and the purpose was just to introduce certain correspondence, and we'll take that correspondence with the defense to see what their attitude is. And secondly, my lord, we indicated that there are proceedings, and I did mention this to the defense, proceedings of the 17th of March, 2022, which are crucial or may be crucial for the determination of this fact. And I don't want to ambush my learned friend, but we've just received a copy of the proceedings just now.
Wait, before that, what do you make of the fact that you received them now,
Yes.
standing there or seated there, and your colleagues don't have, and
Yes.
you are about to address me on them?
Yes, but as we discussed earlier on, they can always raise that in reply, my lord, at a later stage.
Will it not be something new, which is objectionable? Because I think you are placing your colleagues in a position where they may, I mean, especially Advocate Mshololo, where she may have to raise new issues she hasn't
Yes.
risen until now. You see, because for me it is very important that whatever we do it the correct way.
Yes, of course, my lord. We all want to do it the correct way, but
Because if what you are about to come up with is something completely new, it may necessitate that Advocate Mshololo also comes up with something she hasn't come up with until now. Whereas my understanding was that she addresses and you respond, and then she addresses court based on your response without bringing anything new
Yes.
that he hasn't brought thus far.
Yes, but this is based on their own submissions, my lord, that they've just made.
Okay?
Yes.
But with due respect, I would ask that I be afforded an opportunity to go through those proceedings, my lord. Thank you, my lord. They can be emailed to us, my lord. We can just go through them during the lunchtime and then proceed after lunch.
Advocate?
As the court pleases, my lord, they can have a look at that, but as I say, we can introduce those proceedings now. It makes no difference whether they're given the opportunity, because we are going to refer to those proceedings, and they, in response, they can then respond to those proceedings.
There you are.
No, my lord, it defeats the purpose, my lord, of reply after the state has responded. My lord, I'm asking and I'm begging this honorable court to grant me an opportunity to go through those proceedings that the state has just received now before I sit down, my lord.
Advocate Baloy, I know it's not your intention, but the trappings of the approach you come with, in that unfairness may result.
Yes.
And it may be unfairness, may be the last thing any of us
Yes.
wants to be, this matter to be about. If
fair en-
anything,
yeah.
if anything, let it be about the facts and the application of the law on those facts.
Fair enough, my lord. As it's just about time for the long adjournment, we can take the long adjournment at this stage. We will cause these proceedings to be
Yeah, and I think after the long
Printed
adjournment,
and
we will
handed
check
up, yeah.
with Advocate Michololo whether she wants to reopen
Thank
her
you, my lord.
address.
Thank you, my
as the
lord.
court pleases. As the court pleases. I see she's on her feet.
My Lord, may I ask that the interpretation to accused number 5 of the submissions I've made before we adjourn be interpreted, my Lord, before I finish up.
Yes, Mr. Interpreter.
Sorry, my Lord, I'm just checking my notes. Bafethu ke kuningi okushiwo kususela ke ekseni sizozama ke ukuthi ngeke ke sikusho konke. Sizozama ukuthi lokho esakhumbulayo okushiwo sinitshele kona ke. Kuba ke bengafanele ukuthi indlela esikwenza ngayo sizokwenza ke. Ngicela nje nikwazi ke lokho. Ukuqala ke okushiwo lana ngokumayelana nesicelo esenziwe ukuthi kwakungeyi-22 zika April kuwona lo nyaka nkathi ke abamangalelwa bevela phambi kwenkantolo besho ke nokuthi bathini ukuyiphendulela kumacala abawethweswayo ila khona ke noma ke idokodo lesibili aliqhamukanga ke ngaleso sikhathi kodwa lizoqhamuka ngenkathi kunofakazi osebiziwe obizwe uyena umbuso lo wofakazi kuyena ke uSergeant Msiya obekhona la ekseni inkantolo ibingeke yazi futhi ke ukuthi kunale dokodo lesibini uma ngabe lokho ke kwangazange kuvezwe ke ummeli wommangalelwa futhi ke kunemniningwane noma ke kunolwazi olukhona lapha yana ekwakufanele ukuthi ke ludaluliwe kwaseqaleni lokho ke bekuzosiza noma kulekelele ummangalelwa wesihlanu ukuthi ke ayilungiselele ukuthi uzothini ke uma ngabe eyiphendulela kwinsolo ayibekwayo noma ke kumacala lawo awathweswayo futhi ke idokodo lesibini lineyithombe noma line-album yeyithombe zendawo yesehlakalo futhi ke lolo lwazi lelo bekulwazi olusemqoka ke kulona lelicala leli kanye futhi lapho kunestatement sesibili noma istatement sesibili esenziwa uyena uSergeant Msiya la khona ayiphikisayo noma aphikisa lokhu akusho la ebufakazini abethulayo la enkantolo noma uma ngabe ummangalelo wesihlanu wayenalo ke ulwazi lwalo ke idokodo lelo wayizokwazi ke ukuthi ayilungiselele ngendlela efanelekile futhi kunestatement zakhe noma istatement sakhe uBrigadier Ndlovu la khona ke leso statement asange sitshelwe ngaso futhi ke sinobufakazi obusemqoka bakhe uSergeant Msiya osewufakazi namanje futhi ke leyo mniningwane lelo noma lolo lwazi lelo aluzange ke ludalulo noma luchazwe la enkantolo uwarrant officer Meshek Makhubo yena ke unestatement awasenza futhi kulelo docket lelo ngesimo sofakazi abenza istatement noma istatement kwidocket eli-63610 ka-2014 futhi ke esho noma ukuthi lobo fakazi lobo ke noma le statement lelo iyaphikisa ke noma ubufakazi bazo buyaphikisana u636 inkantolo ibisefuna ukwazi ke ukuthi kwakuyiliphi idocket lokuqala kulawo mabili waphendula ke ummeli ka number 5 wathi ke beku636 ngoba yena ke idokodo lelo lavulwa ngo2014 wase u375 yena ke idokodo la ngo2019 futhi ke imininingwane ke ekhona lapho kulelo dokodo lesibili ke kwakufanele ukuba ngabe bayazisiwe noma bayichazelwe ke bengabameli kanye futhi nabo abamangalelwa abamemele futhi umbuso wona ke ngazo zonke izikhathi ubuhlezi unolwazi noma wazi ngalelo dokodo lelo umuntu ngamunye ke unalo ke futhi noma unelungelo lokuthi azi nakuphina noma yikuphi umbuso onako noma ufakazi umbuso onabo akufanele ukuthi kube ufakazi lobo obugcinwayo ke noma obungatshelwa abameli kanye nabamangalelwa sho ke ummeli kamangalelo wesihlanu ukuthi ke lelo dokodo leli lesibini ke akungashiwo ke ukuthi alibalekile noma ke akukho okuhlanganisa nalo lecala leli ngoba ke kunemininingwane laphayana ke emayela nalolu daba lolu oluphambi kwenkantolo njengamanje. Kunabantu laphayana futhi abachaziwe ke ekuthiwa kwakuyibona kufanele ukuthi ke baboshwe noma bajezisweke, kodwa ke umbuso wathatha isinqumo sokuthi ungakwenzi lokho. Endaweni yalokho kwaboshwa yena ke ummangalelo wesihlanu manje osephambi kwale nkantolo. Ukungachaza ke kwalo lelo dokotela lelo kunomthelela, kwaba nomthelela ngoba indlela leyo ummangalelo owayezokwazi ke uma ngabe efundile ukuthi kubhalweni laphayana ayilungiselele, futhi nendlela ke awayezoyiphendulela ngayo la enkantolo uma ngabe wayekwazile ke lokho ibizoshintsha ke kunendlela athe waphendula ngayo ngoba engenalo lelo lwazi lolo. Futhi ke inhloso yalokhu uma ngabe icala noma kwinkantolo yokudluliswa kwamacala ukuthi yazi ke ukuthi besikhona ke isicelo esinjengalesi noma esiyilesi esifakiwe phambi kwale nkantolo elalele lona icala leli. Akasakwazi ke manje ukushintsha ummangalela indlela aphendule ngayo noma ke isinqumo sakhe sokuthi ke athuleke angachazi noma angasho lutho. Nanjengoba sebukhona ke sekhona ufakazi osebiziwe noma ubufakazi ke osebethulwe phambi kwale nkantolo, kube yizona ke lezo izethulo zakhe ummangalelo wesihlanu mayela nalesicelo asenzayo noma sifakayo enkantolo. I'm done, my lord.
Okay.
This is my lord. My lord, I just have one more submission. If I may ask the court to reopen my case, my lord, after I had closed it.
Yes.
Thank you, my lord.
Any objection?
No objection.
No objection.
Thank you, my lord. My lord, I just also want to bring to the attention of the court that the state did confirm that the second docket was only handed over to my learned friend, Advocate Defo, by the investigating officer of that docket in my absentia, and such docket was at no stage furnished to the defense, legal representatives of the applicant or the applicant himself. Lastly, my lord, the state indicated initially that I was aware of the existence of this docket. And I repeat, my lord, that I was not aware. I have not been furnished with the docket, with the second content of the second docket before we pleaded in this matter, as the court pleases. May that also be interpreted, my lord, before the response by the state.
Mr. Interpreter?
Yes, my lord. Okugcina ke noma okunye ke acelile ke ummeli ukuthi akwengezeke kuloko bese kushilo ukuthi umshushisi wayevumeleke noma eshilo ngaphambilini ukuthi idokotela lesibini lanikezwa ke noma walinikezwa ke u-advocate Defo elinikezwa yena ke ummeli kaMangalelo wesihlanu engekho, futhi ke alizange noma linikezwa yena ke uMangalelo wesihlanu noma ke ummeli wakhe, futhi ke uyafuna nje ukuthi agcizelela akuphinda kusho ukuthi ke nanjengoba umshushisi washo wathi ke u-advocate Mshololo wayekadazi ngalelo dokote, yena ke uyakuphinda ke lokho ukuthi wayengenalo ulwazi futhi ke engazange noma engakaze futhi alinikezwe.
Yes. Advocate?
As the court pleases, my lord, firstly, I just beg leave to hand up the transcript of the proceedings of the 17th of March, as I'll be referring to that. My Lord, the recurring theme in the argument on behalf of accused number 5, and to use a musical or literary term, the leitmotif. It's Leitmotif. The leitmotif in the argument of Advocate Mshololo is the following. She argued that the infringement or irregularity arises out of Section 87. The applicant was unable to use the protection offered because defense for accused number 5 wasn't aware of the existence of the information contained in the second docket. And it's already on record, the second docket refers to First Lawrence Case 375-1 of 2019. And just now in her closing argument, she did indicate that she was not aware of the second docket. Well, before proceeding to our heads, we just want to base on this recurring theme that I've just referred to. Just want to refer to the proceedings of the 17th of March 2022. On the first page that took place before Judge Bam. If we look at the first page, it says on behalf of accused number 5, Advocate Mshololo, is actually Mr. Sibia, who's present in court today. And if we go over to page 6, line 5 of the record, there's confirmation that Mr. Sibia is appearing for accused number 5. Maloti was not at court on that particular day. And on the same page, page 6, lines 20, Mr. Sibia says, thank you, my lord. I'm M.M. Sibia, my lord. I'm an attorney. And he says, we have briefed Advocate Z. Mshololo. And if you turn over the page, page 7, the second line until the 7th line, there's a discussion about Advocate Mshololo not being available. And below the page, the second line from the bottom, there's a discussion about the trial date, and the 11th of April is mentioned. And if we go to page 10, line 21.
You said from page, you referred me to page 6, what did you refer to?
On page 6, my lord, I referred to line 5.
Yes.
Line 5 to 7, and lines 20.
Yes.
To 23.
Yes.
Now we go over to page 10, line 21. Advocate Tifo was appearing on behalf of accused 1 to 4, and he's addressing the court as follows. He says, thank you, Your Lordship. I just want to alert the fears on the part of my learned colleague, Advocate Baloyi, as well as the court. I am new before this court, but under oath on the matter. And in the following portion, my lord, is important. Why I'm saying is because there are 2 cases, Your Lordship. This, my lord, is said in the presence of Mr. Sibia. And says, maybe the court may not be aware of that. And when you turn over the page to page 11, the second line, that is why we are here today. We are here to request disclosure in terms of it's inaudible, case 636/10/2014. That is a case that the accused have been charged and are prosecuted for. Then the next line, my lord, is important. He says, and there is another case,
You said page?
page 11.
Yes.
The fifth line from the top on page 11. And this part is important, my lord. He says, and there is another case, all the same incident, 375 of January 2019. We also seek disclosure of the same. And later on, the court then asks Advocate Tifo, and that appears on same page 11, line 18. The court asks him, do the two cases run together? Are they combined now? Then Advocate Tifo answers, no, the two cases are not combined. Initially, I was on brief, then there's an inaudible part. Then the court asks him, will there be separate trials then? You have mentioned two cases. Then Advocate Tifo says, I just want to be educated from the court. I think it's proper for me to bring this forward because during this time I was not briefed on the same case 375 of January 2019.
Yes.
Then he says we wrote a letter and we brought section 6B application to the NDPP. Then the next line, he says the prosecution to stop in this one and then there be prosecution under 375 January 2019. And on the same page, at page 9, line 9, page 12, line 9, he says, and then 375 of January 2019, there are suspected people that must be charged under 375. And he says the number is 7 people. And he says, so it cannot be correct that for the same incident the case can run concurrently. Then the court says, well, I don't know. It is the state's prerogative. I cannot decide about that issue now, can I? And the court at line 20 remarks as follows. What is the point? Are you objecting against the procedure followed by the state by combining the two cases? Then Mr. Tefo at the bottom of the page, line 23, he says, they are not combined. What state is saying when we get to return, in response to section 6B, and it goes over to the next page. The state was saying, okay, can you allow us first to deal with case 636-10-2014, carry on with the prosecution of the 5, then if we fail, then we come back and look for the 375 and look for what you people are alleging to be the correct suspect to be charged under 375, which the number is 7. Then below in the page, the court remarks as follows. it's line 14. Maybe you are missing something. I cannot dictate to the state what to do, not at all. If you have a problem with that, you can apply formally. I do not know why you have not done it yet. It appears to me that you have some or other objection against the procedure followed by the state. I'm not going to attend to it right now. You have the right to bring an application, a formal application. Then on page 14, Advocate Stiffer says, on line 4, and we are going to definitely bring the application as the court pleases. My Lord, I'm just quoting this paragraph to indicate to the court that in the presence of Mr. Sibia, there was already a discussion about First Lores Case 3751 of 2019, and that was on the 17th of March before the have pleaded. And we therefore make the submission, my Lord, that the fact that they say they were not aware of the contents of the second docket is not borne out by the record. Then coming to our submissions, my Lord, we have compiled heads of argument, and I'm just going to take the court through our submissions. My Lord, under paragraph 1.1, in the introduction, we mentioned that the applicant is bringing an application seeking an order in terms of section 317 of the Criminal Procedure Act for a special entry to be made in the record to the effect that the applicant would not have pleaded in the manner he has pleaded had he been finished with contents of the docket in First Lores Case 3751 of 2019, and therefore that applicant's constitutional right in terms of section 353 have been violated in that he was not provided with sufficient details of the charge before he pleaded. And in paragraph 1.2, my Lord, we make the submission that the application for a special entry is premature and ought to be dismissed, and we advance the following reasons. Firstly, and we will refer to the relevant case law in this regard. In paragraph 1.2.1, we say that special entries are a route to the appeal court, and therefore presupposes that there must be a verdict of guilty. And we are making the submission that there hasn't been such a verdict in Kasu. In paragraph 1.2.2, we make the submission that special entries apply only if the irregularity complained of does not appear on record. And Advocate Msholo has just submitted that the full extent of the irregularity does not appear on record. But our submission, my Lord, and we differ from here with the greatest of respect, is that in case the alleged irregularity has already been placed on record and can be relied upon by the defense as the basis of an appeal pursuant to section 316, appeal should a guilty verdict ensue. And we quote section 317, my learned colleague has already referred to that. We are not going to rehash that. At paragraph 1.4, we deal briefly with the wording of the word frivolous or absurd as used in the section. there's a qualification that the court will not make the entry if the court is of the opinion that the application is not made bona fide, or that is frivolous or absurd, or that the granting of the application will be an abuse of the process of the court. That is the qualification that is contained in section 317, and we refer to the case of State versus Cooper, 1977, volume 3, SA, page 13, and the court there described what is meant by frivolous, and it held as follows: frivolous means characterized by lack of seriousness, as will be a point which is obviously insufficient, and the court described absurd as being applying to an application which is inconsistent with reason or common sense, and thus unworthy of serious consideration. The court held that the application must be so unfounded that no reasonable person can possibly expect it to succeed. And the court then referred to relevant section 322, which requires that the impact of the irregularity must be such that a failure of justice has in fact resulted. But this is the test that is applied when the court, when the appeal court is seized with the consideration of such an irregularity. At this point, all that the court is concerned with is to establish as to whether an irregularity has been established. And we point out to the well-known work by Himstra at 31 to 29, wherein he states that the words irregular or not according to law, as used in section 317, are in practice regarded as synonymous, and therefore the word irregularity is used for the sake of brevity, and that is the word we also use in the heads. My Lord, then we deal with the purpose of a special entry. At paragraph 2.1, we mention that the purpose of a special entry is to raise an irregularity in connection with or during the trial as a ground of appeal against conviction under section 3181 of the Act. And we mentioned that section 3181 provides that if a special entry is made on the record, the person convicted may appeal to the appeal court against his conviction on the basis of the irregularity stated in the special entry. Then, my Lord, we refer to the case of State versus Stahi, 2012, volume 2, SACR 311 is the decision of the SCA. At paragraph 16, the court held as follows: the only purpose that the special entry serves today is to record irregularities that affect the trial that do not appear from the record. So even the Supreme Court of Appeal has emphasized that the purpose of section 317 is only limited to this specific purpose that is on respect of irregularities that don't appear on record. And they then also comment on the fact that this process is outdated, and the word that they use is, they said special entries are an acronym dating from the time when the right to appeal in a criminal case was severely restricted, and this dates to before 1948, my lord, when before the appeal to the High Court became possible. And the court said this procedure was introduced when and assisted in the administration of justice prior to 1948, after which time fully fledged appeals from the High Court became possible. So, my lord, we're dealing with a procedure that's, outdated, and this is what the Supreme Court of Appeal held. And in paragraph 2.3, we refer once again to the work of commentary on the criminal procedure by the writer Ditoy and others, where in the state at paragraph 331, page 31 to 32, that it is clear that section 317 procedure must not be followed where the irregularity or illegality appears from the record of the case, because the irregularity can simply be raised as a ground for appeal in the appeal under section 316. And, my lord, we submit that the issue regarding the disclosure of the second docket, First Lords Cast 3751 of 2019, has been fully canvassed on record, and that it is therefore not necessary to make a special entry in this regard, and that the application ought to be dismissed. My lord, we also at paragraph 2.4 refer to the case of State versus De Vries and others. 2012 volume 1, SACR 186 is also the decision of the Supreme Court of Appeal. At paragraph 29, the court held that special entries should not have been made because they concern an attack on rulings made by the trial court during the course of the trial, and which form part of the record. We again refer to the case of State versus Nkambinde and others, 2017 volume 2, SACR 431, also decision of the Supreme Court of Appeal, where the court held that, as is shown below, all of the so-called, and I think my learned friend also referred to this passage. We're not going to repeat that. Then at paragraph 2.6, the learned author in commentary on the Criminal Procedure Act states that the correct approach in such an event is that irregularity or illegality should form the basis of an appeal in terms of section 316. And we also refer to the work by Professor A. Kruger, Himstra Criminal Procedure, and he states that the special entry provisions of section 317 have little right to exist when the irregularity appears from the record. And when the irregularity appears on the record, it is unnecessary to use the process in terms of section 317, because the irregularity can simply be raised as a ground for appeal in the appeal under section 316. We therefore, my lord, submit that the application for a special entry in this case should be dismissed.
So you are saying, to the extent that the issue of the second docket has been canvassed, I think it has also been a subject of a question to Sergeant Musia.
Yes.
It also featured in some of the issues that were raised by the former representative of accused number 1 to 4. It has been raised ad nauseum, if you ask me, in the sense that that has been repeated to an extent that the court was even drawn into calling Advocate Defo to a consideration of the fact that some of the issues were being repeated endlessly.
Indeed, my lord, that was raised extensively by Advocate Tifo. And as we've just pointed out in the record of the 17th of March, he already at that stage raised it. The one point that Advocate Mshololo buttress, and I just hope I heard her correctly when she mentioned that if it wasn't for this application, the court would not have been aware of the existence of the second docket. I hope I heard that submission correctly. If I didn't, I then apologize to my learned friend. But all that we're saying is that, my lord, this matter, as the court mentioned, it has been raised ad nauseum on record. My
So
lord,
if I understand you well, I mean, if we go to the purposive mode of interpretation of statutes, the ultimate goal intended is that issues that constitute irregularities should feature in any proceedings in a way that it will be possible for them to be used if the parties choose so, for them to be used in order to canvass towards a particular eventuality in an appeal process.
indeed, should a conviction ensue.
And you are saying before Advocate Mshololo rose to make this application, that was already in place.
Indeed, my lord. And as we'll be pointing out later on, that Section 317 postulates that that there has to be a guilty verdict. And my lord, the reason therefore, it's simply this.
Yeah, if we go back to the issue of the guilty verdict in terms of the
Yes.
authorities.
Yes, that is the next paragraph that we're referring to.
Page,
If the accused are acquitted, then
page,
it's page.
the pity your document is not,
Yeah,
the
I'm sorry,
pages are not
that will be
numbered.
paragraph 2.8.
2.8,
It's
okay.
page 5. So,
Where the case of Sitole is
yes,
cited. Okay.
yes, by the learned Judge Bochots.
If I may ask you also, like I did with your colleague, the heads, these heads, have they been forwarded to the secretary in word format?
Yes, yes, my lord.
In word format?
Yes, yes.
All right,
They have
okay.
been. And this judgment was delivered on the 12th of September 2012. And the court held at paragraph 11 that clearly, and we quote from the judgment, the special entry provision is not a process directed to a different result other than the hearing of an appeal. So, she, once Judge Boch, the judge confirms or follows the, what the Supreme Court of Appeal held. And my lord, because
And what would your comment be? I at the same time hear Advocate Mshololo to be saying that that is well appreciated from her side, but she wants to raise this so that in the event where it becomes necessary and the content of the special plea needs to be raised, that will have been done now rather than later.
yes, but
That's what I hear her to be saying.
yes, but we're saying it's not necessary, my lord, because that's on record, and this is what the Supreme Court of Appeal is saying, that if an aspect is on record, then there's no need for a special entry.
Okay.
And Judge Sechwell's judgment then continues. She holds as follows. With reference to the special entry, it is a procedure which enables an accused to raise alleged irregularities in the trial not apparent from the record to be heard by an appeal court, not apparent from the record. Such irregularities could otherwise not be considered by an appeal court because they do not appear from the record. And Manot, in this case, the record is replete with references to First Lawrence Cast 3751 of 2019. And Judge Sechwell continues, accordingly, the irregularities envisaged in Section 317 tend to cover matters which only become apparent after the conclusion of the trial and which are not apparent from the trial record. And she gives examples of such matters. She says they range from inadequate interpretation facilities, where there was a breach of the attorney-client relationship, and the evidence so obtained was used against an accused, where there was the removal of an assessor by the presiding judge for reasons that were not debated in open court, or where there was the failure of the prosecutor to disclose discrepancies in a witness statement. This was, naturally before the Chabalala decision. And this is the point that we raised earlier on. The purpose of the special entry provision remains to permit such issues to be determined by an appeal court where they cannot initially be raised on appeal simply because they do not appear on the record. We then refer to the case of Cephas and others versus Attorney General, 1989, Volume 1, SA at 821, where the court held as follows. Once again, the court starts by explaining the purpose of Section 3171. It says the special entry procedure is designed to furnish an accused who has been convicted with a ground on which he can appeal against his conviction, in the same way as, say, an alleged lack of sufficient evidence would constitute a ground on which he can appeal. The procedure is a useful or perhaps even necessary one when the irregularity or illegality complained of is discovered only after the conclusion of the trial. The procedure need not be followed when the irregularity or illegality appears from the record of the case. For in such an event, the irregularity can then be made a ground of appeal under Section 316. And at paragraph 2.10, we again quote from the work of the author, Himstra Criminal Procedure. He states that paragraphs 3, or pages 31 to page 31, that while there are two routes to the appeal court, namely via 316 or 317, their purpose is to bring an appeal before that court. Along the limited route of a special entry, reliance can only be placed on irregularity and only in respect of a conviction. Once again, the author emphasizes that this reliance on 317 can be placed on only in the case of conviction.
Advocate, there's a note I made over lunch, looking at what was before me already. It seems I did not bring it with, can we adjourn just for 5 minutes for me to obtain that, because it's something I need to raise with you before you
As a
sit
court,
down.
please, my lord, as is in any case before 3, we know that the accused must be back in prison at least by 3 o'clock.
Is it 3 or 3:30? Can,
Is it 3:30? I thought we need to adjourn at 3.
I think you should ask the people that accompany the accused.
They indicated, my lord, it's 3.
What time is it now?
It's about 10 to 3.
Okay, then continue until 3. Then. I will raise, if you finish, then we'll stop, so that I raise what I need to raise maybe tomorrow.
Let's go, please. At paragraph 2.11, we refer to the case of Nkabinde and others, 2017 volume 2 SSCR 431. And the court, the Supreme Court of Appeal held that the making of a special entry is not just there for the asking. The court must satisfy itself that the application is bona fide and not frivolous, absurd, or abuse of process.
There's something you raised about instances where the discovery of the irregularity is belated. And you said that that is one of the instances where it becomes relevant to raise. How will that be raised if it's discovered late and maybe even after verdict?
Well, the section provides a period of 14 days within which that irregularity can be raised. That is now if it's not on record, because if it's on record, then it's not necessary.
Yeah, of course, I'm referring to
raise
instances where it is not apparent from the record.
From the record, yes, as the court pleases. We again refer to Himstra Criminal Procedure at paragraph pages 29 to 31, where he says that Section 31 postulates an irregular or departure from the formalities, rules, and principles of the criminal process according to which a criminal trial must lawfully be initiated and conducted. And we emphasize what he says next. He says, not any departure found an application in terms of Section 317, I'm sorry, the 3 is missing there, but only that can be described as irregular. And he says the particular factual context of the conduct complained of is often decisive of conduct that may be found to be irregular. He says the basic principle is clear. A special entry requires that the irregularity be so important that because of it, the accused is in a weaker position with regard to the trial than he or she would have been had the formalities and rules properly been taken into account. And he says in addition, clause, he refers to clause 35 and 39(2) of the Constitution. And we lastly deal with the grounds of irregularity raised by the applicant. And we summarize them as follows. The applicant would not have pleaded in the manner he has pleaded had he been furnished with contents of the docket, Foslores Cast 3751 of 2019, and therefore that his constitutional right in terms of 353 of the Constitution have been violated, in that he was not provided with sufficient details of the charge before he pleaded. And in her address, Advocate Mshololo mentioned the fact that they were not furnished with further particulars in terms of Section 87. But, my Lord, my understanding is that Section 87 is there for a formal request. You know, it makes provision that further particulars may be requested. The state cannot just give further particulars. The defense must submit an application, state what particulars they need to enable them to plead. It's not like as night follows day, that in every instance the state must furnish the defense with further particulars. They must be specifically asked for.
So you are saying to Advocate Mshololo, it is you who did not ask for it?
Well, I'm just responding to an argument that we didn't furnish her with further particulars.
I'm saying your answer then is that you were not. It was not furnished because you did not ask.
Yes. If you were asked to say, give us, particulars regarding ABC, we would have furnished that. And we mentioned that the applicant pleaded not guilty and exercised his right to remain silent. And we argue, my Lord, that it is not immediately clear how else he would have pleaded, as he contends, or what such plea would have entailed. When Advocate Mshololo argued earlier on, she says that various pleas would have been raised, but she says they could have objected to the charges, but my Lord, we submit that, and we say this with the greatest of respect, that the fact of the matter is they pleaded not guilty and disclosed no basis of of their plea. They made no admission.
Well, the other aspect that needs focus is that for now, it is not for the court to even assess the effect of the lack, if not failure, to disclose. It is for the court to look at the failure to disclose, and then to note it, so that if there is conviction and there is a decision to appeal, then that will have been put on record for then. But then your answer to that is that
it's already on record.
It's already on record, number one. Number two is that it's not like it consists of anything that the defense requested, whereupon the state failed to provide.
Yes. Indeed, my Lord. And we say that if the accused perhaps, and we just, postulating that if, say, for instance, he pleaded guilty or made admissions, either in terms of Section 1152 or Section 220, then the contention have been understandable. But in this instance, pleaded not guilty, did not make any.
Would that be a firm issue to raise? Because could it not be that by some twist or turn of events, had the defense been aware, they would not even have chosen not to disclose the basis of their defense?
Well, the fact is they didn't disclose any basis of their defense, they remained silent.
What I'm saying is that much as they did not disclose, could it not be that had they been aware of the second docket, they could well have chosen not to remain silent?
Yes, but they can still put to the witnesses, their version. We're saying, the boat hasn't sailed. They can still put to the witness, or even make admissions can be made during trial. They can still make admissions at this point in time.
Okay.
And I also just want to mention one aspect, my lord, that even during the plea proceedings, that is the proceedings of the 22nd of April 2022, at page 43, the second line, it's Mr. Tefo addressing the court. Your Lordship, that in this matter, other than this case 636, there is another case 375 of the same incident of the murder of Senzo Meyiwa, or the incident that happened at the same address for the reason that we are in this court for, and in that case as per the charges. So also during the plea proceedings, and if I remember well, that was at the stage when the state was handing in the centralization directive from the NDPP, wherein the directive mentioned only 636/10 of 2014, and Advocate Tefo was saying, in addition to that docket, there's another docket that hasn't been mentioned, but we've seen now that in the latest directive that has been handed up this morning, that 3751 of 2019 is also included as per Exhibit AAA.
What would you say about the following? When this docket was finally openly spoken about in this case, Advocate Mshololo requested time amidst much objection from the representative of accused number 1 to 4, time to go through that docket so that she can be ready to deal with issues that may flow from therein. If you remember, that became a very huge bone of contention, because the representatives of accused number 1 to 4 thought the issues of that docket should not cause that kind of a postponement. But today, Advocate Mshololo raised an issue about the fairness in this trial. You think it's an issue you should answer to now, or is it an issue that you would rather let lie for now?
My Lord, I will answer it now. In paragraph 3.3, we mentioned...
3.3, you say?
Yes, 3.3 on page 8. we mentioned that after the disclosure of the second docket, First Flores Cast 3751 of 2019, the applicant was afforded over 2 months to peruse the docket. I think the last sitting, my lord, was around the 15th of June. And we are saying it is therefore submitted that the period of over 2 months that the applicant was afforded to peruse the second docket has mitigated any disadvantage that he might have been.
Was there no kind of a train of some platforms then, in the sense that they had already pleaded?
Well, this is the point that we're making in the next paragraph. We're saying that First Flores 375 does not form the subject matter of the charge. And we are saying that it is thus inconceivable how its disclosure would have affected how he pleads. It can certainly be used in cross-examination to test the credibility of the witnesses. That's the point that we made this morning. We mentioned the applicant contends that the contents of evidence contained in the police docket 375-1 of 2019 was obtained immediately after the incident occurred from the same crime scene as First Flores Cast 3610 of 2014, which the applicant pleaded to. We are saying that this is a docket that was opened some 4 years later after the initial incident on the 26th of October 2014. And my learned friend has extensively referred to the contents of, or perhaps not extensively, but she has to some extent referred to the contents of those statements. And we're saying here, my lord, that it cannot be disputed that the majority of the statements contained in First Flores Cast 636-10 of 2014, which has already been disclosed to the defense, are also contained in the second docket. I'm not saying all the statements, but we're saying the majority of the statement. There are few statements that are not contained. So we are saying the majority of the statements in First Flores Cast 636-10 of 2014 have already been disclosed to the defense, and we therefore submit, my lord, that the only statements that were contained in 375 were just perhaps more in the minority, and therefore that any disadvantage that they might have suffered, it's limited. And lastly, my lord, was saying that the first state witness is under cross-examination, and that the statement contained in the second docket can still be used to test the credibility of the witnesses, as has been done. And my lord, we make the following point, and we just want to be careful not to perhaps misread the submissions of counsel, but we are saying that if one looks between the lines, it appears that reliance is being placed on Exhibit C, which has been disavowed by the DPP of Johannesburg, and which is an unsigned draft indictment, and that has not been proven in terms of the normal rules of evidence. And in paragraph 3.9, we refer to the case of State versus Taba, 1983, 3 SA 717. The court held that refusal to make special entry on grounds that granting of application would constitute an abuse of the process of court is competent only when there is no prospect at all of appeal based on the alleged irregularity succeeding. We therefore, my Lord, submit that, that there is no prospect at all of the appeal based on the alleged irregularity succeeding, and that the court ought not to make the special entry sought. There's only one aspect, my Lord, that will canvass tomorrow, but because of the lateness of the hour, maybe we can adjourn at this stage.
I am fully aware of the constraints that are attendant to the dynamics of the case that is running in these proceedings. But for what it's worth, I wish to find out. Maybe I should have done so before lunch, so that you find out from those that transport the accused persons from various points, the possibility of an earlier start, if any. I know that there are security issues also at play to be considered, but maybe now that I didn't do it in time today, may you, together with your colleagues, explore possibilities. The other time, Mr. Tawane, did you have difficulties with an earlier start? Did you have a problem with an earlier start?
No, Your Lordship. Even if we once suggested 9:30, I didn't have a problem.
Advocate Mshololo.
My Lord, without compromising each other, my Lord, I will ask that we stick on 10 o'clock, my Lord. It's
Well
more
understood.
convenient to all of us. Thank you, my Lord.
It's not anything I want to push. I was just exploring.
Oh, thank you, my Lord.
May the accused rise. Due to the lateness of the hour, we are postponing this matter overnight. We are postponing it with the accused in custody to the 6th of September 2022.
Ngoba ke isikhathi sesihambile bafethu kahlehliswa icala hlehliselwa kusasa kuzobe kuyi-6 zika September kuwona lo nyaka. So qala ke ngo-10 ekseni.
Anything else?
None, my Lord.
Well, I'm all right.